Hey class, welcome to week 4. We are going to be discussing agency discretion this week, and one of the most important cases for administrative law related to agency discretion is the Chevron case, and that's why you see this nice little chevron pattern here on our first slide. So what do we mean by agency action and agency discretion? Discretion's the ability to choose between two or more actions, and that includes choosing between an action and an inaction. And discretion's the first type of authority agencies possess. So agencies perform rulemaking and adjudicatory functions, so issuing regulations and holding trials, and they do have discretion in carrying out these functions. And these two functions can be formal agency action, but most agency action is informal, and that includes issuing regulations and holding adjudications. Now, informal agency action is still governed by statutes, but if the statute doesn't provide explicit instructions on how an agency should operate in any given situation, agencies get to choose how they want to operate. They can exercise discretion. Now, your policy analysis memo that will be due at the end of the semester, it's actually a showcase of agency discretion because what you're going to do is recommend that an agency select a certain course of action from the options available. And again, that can be a decision to not take an action at all. Agency discretion is a bit of a Goldilocks problem. We don't want agencies to have too much discretion, but we don't want them to have too little discretion. We want to end up with just the right amount. And that's easy to say, but it is hard to achieve. So the problem is that too few rules lead to too much discretion. And by rules, I do mean regulations, but I also mean internal rules and policies. So if you don't have enough rules, then agencies, through their personnel, they can act arbitrarily and inconsistently and basically do whatever they want without being constrained by law and policy. But on the other hand, if you've got too many rules, that leads to too little discretion, and that can be just as bad. Primarily because it can lead to inflexible agencies and it can really grind the bureaucracy and thus our whole process of government to a halt. So as an example of too much discretion and how to appropriately limit it, our textbook mentions police high-speed chases. So back in 1990, the National Institutes of Justice, which are part of the U.S. Department of Justice, issued a report about high-speed police chases. And that report noted that police across the U.S. are engaged in hundreds of these high-speed automobile chases every day. And many of those chases resulted in serious property damage, personal injuries, and even death. And those negative consequences of high-speed chases, they were not limited to the individuals being pursued or even to the police officers in pursuit, but also to many, many innocent bystanders. So that National Institute of Justice report noted that 3 Supreme Court opinions that had been handed down in the late 1980s created basically a foundation for liability in high-speed chases if municipalities and police departments had not adopted reasonable policies or provided adequate training. So these policies were intended to limit police discretion to engage in high-speed chases. For example, by specifically prohibiting high-speed chases for minor traffic violations and for other misdemeanors. And this ultimately served both the law enforcement agencies and their communities by forcing police officers to make better choices about when to engage in high-speed chases. Now, that is not to say that police officers still don't engage in chases, including high-speed chases that are contrary to their police department policies. Individual agency personnel can always act in a way that abuses discretion and violates policy, and obviously we are seeing that in the news today with regard to police use of deadly force, especially when it comes to people of color. But at least if there is a policy in place, the hope is that fewer people are injured and those who are injured have some avenue to seek recompense. So on the other hand, too little discretion, that can be just as bad. It can lead to inflexible agencies. You might have experienced this if you've ever had to deal with your county permitting office. Say you want to build a privacy fence. You might have experienced the drudgery and the red tape and just jumping through hoop after hoop that comes with dealing with an overly bureaucratic agency that has very little discretion. Your permitting officer might demand information that seems completely irrelevant to your project, and they're making that demand because they are forced to check off every box on their list. So if the permitting office has no discretion to decide, for instance, that it doesn't need you to get a new land survey because your new fence is replacing an existing fence, it's going to be built in the exact same spot, that permitting process is going to grind to a halt while you go pay a bunch of money for a property line survey. And what should be a simple permit turns into something that is far more complicated and costly. So ironically, agencies can have a lot of discretion if there are not enough rules that tell them what to do, but also if there are too many rules, because in that case, agencies can't follow all of those rules and they start discarding them here and there. So for instance, you can think about OSHA, and our book talks about this as well. There are so many OSHA regulations that encompass almost every part of company life that you can think of, from sitting at your desk to highly complicated manufacturing plants. It is simply not possible for OSHA inspectors to enforce every last one, so they have to pick and choose to enforce the rules that they believe are most important, and that is an exercise of discretion. Let's take a look at two different examples of the IRS's exercise of discretion, both of which inflamed public opinion. So first, the IRS often uses its discretion to not enforce a law known as the Johnson Amendment. The Johnson Amendment is a tax code provision, and it says that tax-exempt groups like churches and charities can't speak for or against particular political candidates. Now, the Johnson Amendment was approved by a Republican Congress, signed by a Republican President, Dwight Eisenhower, and supported generally across the board by both political parties. As it turns out, the IRS routinely enforces the Johnson Amendment when it comes to charities, but not for churches. Now, churches and charities, of course, are allowed to make political commentary. They can advocate on behalf of their preferred candidates, in the course of carrying out their ordinary activities. That right is protected by the First Amendment. But charitable organizations, including churches, are not supposed to engage in this type of political advocacy if it involves spending more than a minimal amount of funds. So for instance, during a sermon, a minister can talk about political candidates, but the church is not supposed to hold fundraisers for the candidates. And polls have shown that majorities of both the general public and the clergy actually do oppose churches endorsing political candidates. Even so, you might remember, it was a while ago now, but back in 2008, the Mormon Church invested really heavily to pass Proposition 8 in California that banned same-sex marriages. Then again, in 2012, the Mormon Church campaigned very, very heavily for Mitt Romney, who was the Republican candidate for president. So throughout that time and currently today, there have been a number of petitions and even advertisements, like big billboards taken out in Utah and elsewhere, asking the IRS to revoke the Mormon Church's tax-exempt status. Now, for a while in recent years, the Johnson Amendment was sort of hotly debated because President Trump vowed to, and I quote here, destroy the Johnson Amendment, which he can't do. No president can. It's up to Congress. And opponents of the Johnson Amendment say that it stifles free speech. But remember, churches are still free to speak about issues, including political issues. And they can do that in the course of their regular business. They just can't raise and give money to particular candidates. Proponents of keeping the Johnson Amendment, which polls routinely shows over 50% of Americans, including clergy, say that repealing it would let churches basically act like super PACs. They would be so political that they would lose their nature as churches. Back in 2015, Lifeway, a Christian polling firm, found that 79% of Americans, and that includes, religious Christian Americans, because that's who Lifeway was polling, 79% thought that clergy should not be endorsing candidates during worship services. Now, for years, more than 2,000 primarily evangelical Christian clergy have been deliberately violating the Johnson Amendment as a form of protest. And while there have been over 2,000 of them doing it, the IRS has only audited one and has not punished any of them. So that's a prime example of agency inaction. The IRS has decided not to enforce this law when it comes to churches. In our second example, the IRS used its discretion to target certain political groups, and this happened during the Obama administration. So in 2013, the IRS admitted that it had selected political groups who were applying for tax-exempt status for sort of intensive scrutiny, and the IRS did that based on their names or political themes. So at the time, then Attorney General Eric Holder ordered the FBI to investigate, and the FBI found that for about 2 years, the IRS had essentially placed on hold all tax-exempt applications, so it wasn't processing them, from organizations that had Tea Party or Patriots in their name. Now, the IRS did not deny these applications, but only 4 of them were approved in this 2-year period. During that same period, the IRS had routinely approved applications from either non-political or presumably left-leaning groups. Although the IRS, the FBI found, did select some of those applications from these more liberal groups for increased scrutiny, and it did deny several of those applications. After that FBI investigation, Republicans and Democrats in Congress, as well as President Obama, a Democrat, agreed that the IRS needed to refocus on applying the law in a fair and impartial way. Now, the FBI eventually announced that it did not find any evidence of enemy hunting, that is, specifically targeting political groups with which IRS employees disagreed. Even so, a number of IRS officials resigned and some were fired. The FBI's investigation also found that many IRS personnel who were charged with enforcing, both regulations and policies, they didn't fully understand those regulations or policies. And that, of course, is troubling in and of itself. So as we'll see, discretion's got both benefits and drawbacks. There are 2 major benefits of agency discretion. First, it does inject some humanity into the process of governing. Public administrators, they're human beings. We're human beings. We take into account human emotions and hopefully common sense. If you think back to the permitting office example, you want that county permit officer to use some common sense and realize that if you're simply replacing a fence, you're not moving it, there's no need to force you through the time and expense of getting a new land survey. Second, discretion allows for fairness in situations where we can't foresee every possibility. Congress cannot know every single issue that might arise from a statute and how that issue might impact the regulated parties or the public. And that's why agencies need discretion to deal with issues as they arise, sometimes on a case-by-case basis. However, too much discretion can create agencies that act arbitrarily and inconsistently. And that not only makes agencies unwieldy and difficult to control, but it also makes things really hard for individuals and for businesses because we all, people and companies, need a stable regulatory environment so that we can basically plan our futures. Now, an agency's discretion, of course, is not unlimited. The Constitution creates the biggest check on agency discretion, and we are going to talk about that a little bit later in the course. In addition to the Constitution, there is the non-delegation doctrine. There are agencies implementing statutes, the ones that create the agency. There are the statutes that direct agencies to carry out certain laws. So those statutes provide limits on agency discretion. And then there is the Administrative Procedure Act, and that limits agency discretion and agency action because it requires agencies to adhere to certain rules when carrying out their functions. And we're going to talk about the Administrative Procedure Act, the APA, momentarily. Additionally, the President and Congress can impose limitations on agencies via executive orders for the President, and then for Congress, via the budgetary process. Remember, it's Congress that holds the purse strings, and also the Congressional Review Act. Judicial review also acts as a check on agency discretion, but as we will see in a moment, it is a lot easier to go to court because of an agency's action than it is because an agency decides not to act. So the case of General Motors versus the Federal Energy Regulatory Commission, or FERC, this is a case of agency inaction. So FERC had issued an order, it was order number 467, that prioritized the delivery of natural gas to individual consumers during periods of curtailment, so when there were natural gas shortages. And under FERC's order, the highest priority customers, the ones who were going to be last to be curtailed or cut off from their gas supply, were residential customers and small businesses. So in this GM case, FERC decided not to act. And while the name of the case includes both GM and FERC, it does not mention a company called Pipeline, which was at the heart of the case because it distributed natural gas. So the red line on the image on the lecture slide, that represents Pipeline's pipeline of gas. And as you can see, along its pipeline, the company sold gas to utilities in different states. And those utilities in turn resold the gas to residential and business customers. So one of those utilities was Northern Illinois Gas, NI Gas. And GM was one of its customers. And so what this means is that Pipeline sold gas to NI Gas, which resold it to GM's plants. At the time, in the 1970s, there was concern over whether we had enough natural gas to power the country. And fearing that the country was running low on gas, FERC issued this order, Order 467, that required all natural gas suppliers to have curtailment plans in place to conserve natural gas. And so in the event of a shortage, FERC required that those natural gas suppliers were going to give priority to residential customers and small businesses. And this is basically because FERC did not want people to freeze to death while bigger companies like GM gobbled up all the natural gas resources for their manufacturing plants. So this is why FERC specifically required gas companies to give priority to residential customers. Now, at one point, Pipeline, the company, thought it was going to have to cut back or curtail its natural gas supply. And as required by FERC, Pipeline filed a curtailment plan. And that plan had an impact on NI Gas's ability to distribute gas to its customers, including GM. So because Pipeline's curtailment plan affected GM plants, GM went to FERC and said, hey, you can't approve Pipeline's plan. It has got far too much of a negative impact on our business. And GM further argued that FERC had to hold a formal adjudication. Now, we will talk about those later in this class, but it's basically a formal style hearing. And so what GM was arguing is that FERC had to hold this hearing before it could approve Pipeline's curtailment plan. Now, in this case, FERC actually had issued a notice to the public about curtailment plans, and it allowed public comments. These are informal actions. We will talk about them later. But because of those informal actions, FERC ultimately decided that it was not legally required by its statutes to hold a hearing. So after it reviewed these public comments, FERC decided not to take action. It allowed Pipeline's curtailment plan to stand. GM, suffering from that curtailment plan, or thinking it would suffer, sued in the DC Circuit Court. And that court basically said, sorry, GM, if Congress gives an agency discretion to act or not act, and the agency decides not to act, we, the courts, cannot step in and tell an agency that it must act. Now, what this means for us as individuals and for businesses is that it is much easier to challenge an agency action that causes harm, and it is much harder to challenge an agency inaction that causes harm, because the agency has a discretionary decision not to take that action. Two other limits on agency discretion are the non-delegation doctrine and the agency's implementing statute. So let's first take a look at the non-delegation doctrine. So why do agencies have the power to issue regulations which have the force of law? The short answer is because Congress gives it to them. Our government bureaucracy operates under the assumption that Congress can authorize the executive branch to regulate basically anything that Congress itself could reach. So working conditions, pollution, financial products, what have you. There is, however, a doctrine called the non-delegation doctrine, and it states that one branch of the government must not authorize another branch to exercise the power or function that the branch is constitutionally authorized to exercise itself. So, for instance, if the Constitution in Article 1 vests all legislative powers in Congress, the non-delegation doctrine would say Congress cannot delegate those powers to another branch. If that is true, then why do we have agencies issuing regulations? Well, first, there is a fairly heated scholarly debate about whether the framers of the Constitution actually had a problem with the idea of Congress delegating its authority. You can read a bit more about that in the Atlantic article that I've got posted in our classroom. But let's assume that the framers really did not want Congress to delegate its authority to another branch. If that's the case, how do we expect Congress to have the technical knowledge to legislate across all manner of complex fields? Well, the answer is that Congress, even if it can't necessarily delegate its lawmaking authority in whole, is allowed to seek assistance from another branch. Congress often seeks assistance from administrative agencies in the executive branch. And part of this assistance is calling upon agency expertise to issue regulations that fill the gaps in the laws that are passed by Congress. Now, there are limits. Congress cannot simply hand over its powers to an agency. Congress has to provide what we call an intelligible principle to guide the agency. And then the agency must act consistent with that intelligible principle. So you can think of the intelligible principle as a sandbox created by Congress. The agency can only play, that is regulate, within the confines of that sandbox. Outside the sandbox, the agency has no authority to regulate. So the non-delegation doctrine allows courts to strike down laws passed by Congress when, in the court's view, those laws give the executive branch too much authority with too little guidance on how to properly use that authority. So in other words, if the courts find that Congress never created that sandbox in the first place, then there is no intelligible principle that agencies can follow. Now, the biggest limit on agency discretion, even more so than the Constitution, is the agency's implementing statute. That's the statute that Congress passes to create the agency. And along with other statutes related to an agency's duties, the implementing statute is where agencies get the bulk of their authority to act. So for instance, the Dodd-Frank Act created the Consumer Financial Protection Bureau and tasked it with carrying out certain duties, such as setting up a consumer complaint hotline and prohibiting unfair, abusive, and deceptive actions by financial institutions. So the Dodd-Frank Act, that is the CFPB's implementing statute. And these implementing statutes have to contain this intelligible principle through which Congress communicates its desire to obtain assistance through agency action. So when agencies issue regulations through the rulemaking process, they have to do so consistent with the implementing statute and Congress's intent. So for instance, the Consumer Financial Protection Bureau cannot suddenly decide to regulate space exploration because that is not consistent with the intent of Congress when it created the CFPB. That's pretty obvious to the average person. Less obvious to the average person is that the CFPB can't decide to regulate in such a way that limits another agency's authority. So for example, the Federal Trade Commission is authorized to regulate certain financial transactions, including certain types of debt collection. And not only does the CFPB's implementing statute not grant the CFPB that authority, but it explicitly denies the CFPB the authority to muck about in the FTC's sandbox. So if the implementing statute specifically denies an agency some type of authority, the agency cannot seize that authority by ignoring Congress and regulating anyway, because in that case, the agency lacks the discretion to override congressional intent. So if Congress tells the Consumer Financial Protection Bureau that it can't intrude into areas regulated by the FTC, then the Consumer Financial Protection Bureau's sandbox does not include areas covered by the FTC's sandbox. Additionally, agencies don't have the authority to regulate if that authority is based on an unconstitutional delegation of power. For example, Congress cannot say, hey NOAA, that's the National Oceanic and Atmospheric Administration, hey NOAA, hey EPA, figure out what to do about the oceans. While both NOAA and the EPA are authorized to regulate certain matters related to the oceans, such a broad statement from Congress, it lacks an intelligible principle. Do what about the oceans? Where? When? How? So by failing to provide an intelligible principle, Congress fails to create that sandbox in which the agency is allowed to play. And if Congress does not provide that sandbox, the delegation of power is unconstitutional because it is overly broad and it allows an agency to usurp the legislative power that's granted to Congress by the Constitution. Another major statutory limitation on agency discretion is the Administrative Procedures Act, the APA. After the New Deal, which brought forth a burst of agencies and agency action, Congress became concerned about these expanding agency authorities and also about the separation of power issue inherent in agencies. President Roosevelt, architect of the New Deal, agreed with Congress that the agency's ability to exercise legislative, executive, and judicial branch authority was a problem. Neither the president nor Congress wanted unconstrained agency action because that could fly in the face of the Constitution. And thus the APA was born. The APA acts as an administrative Bill of Rights for all of us who are regulated by agency action. And so that is basically all of us. Unless you manage to live completely off the grid, hunt and grow your own food, make your own clothes, never get online, totally avoid interacting with society, you are going to be regulated by agency action. And the APA creates a framework that limits agency discretion. So for instance, agencies must keep the public informed about their organization, their procedures, and their rules and regulations. Agencies must allow the public to participate in the rulemaking process. Agencies are required to follow uniform standards for formal rulemaking and adjudication, and formal agency actions are subject to judicial review. Now, the APA does not provide concrete time limits for agency action. It leaves most deadlines for Congress to establish, if at all, in the particular agency's enabling statute or another statute that authorizes the agency to regulate. But even absent a specific statutory deadline, the APA states that an agency must, quote, proceed to conclude a matter presented to it within a reasonable time, end quote. So thanks to the APA, courts can compel an agency action that has been unlawfully withheld or unreasonably delayed. And what this means is that the APA provides individuals and organizations with a cause of action, the ability to sue, when an agency takes an unreasonable amount of time to act. Now, a claim of unreasonable delay can only be brought against an agency for actions that the agency is legally obligated to take. An agency must be required by law to act in order for us to establish a claim that the agency has unreasonably delayed in acting. So this is similar to what we saw in the GM versus FERC case. If an agency is not required to act, it can be very difficult to challenge that inaction. But if an agency is indeed required to act, then it can only drag its feet for so long. So for example, Dodd-Frank requires the Consumer Financial Protection Bureau to collect information that might be used to identify instances of discrimination in small business lending. And even though Dodd-Frank was passed in 2010, the Consumer Financial Protection Bureau had consistently failed to implement that provision. It had reasons for doing so. It was busy with other important things. But anyway, it took a very long time. Now, the Consumer Financial Protection Bureau has no choice. It has to develop the small business lending regulation because it was hauled into court. And then rather than let the case go towards a decision by judge or jury, the CFPB settled the case with the plaintiff. In this case, that was a group called Democracy Forward. So the CFPB, because it dragged its feet for so long, has now been forced to take up this regulation. Another limit on agency discretion is the Congressional Review Act, the CRA. That was part of the GOP's contract with America back in the 1990s, but it was signed by Democratic President Bill Clinton. The CRA allows Congress to engage in an expedited review of any new federal regulations, and Congress can overturn those regulations by passing a joint resolution. So that means both houses of Congress have to agree. And Congress has 60 legislative days to do this. Now, legislative days, that means days when Congress is actually in session. So that is very different from business days and even more different than calendar days. So Congress has a lot more than what we would just think of as 60 days to do this. If Congress does pass a joint resolution and overturns the regulation, then the agency that issued that regulation is prohibited from reissuing a substantially similar regulation unless Congress authorizes it to do so in a subsequent statute. Now, prior to 2017, the Congressional Review Act was successfully used only one time. But after the 2016 presidential election, the Congressional Review Act really took off. The 115th Congress used it 16 different times to roll back Obama administration regulations, even ones that were supported by years and years of scientific study and were very popular with the public. So a couple of examples of environmental regulations that were rolled back by the 115th GOP Congress include the Department of Interior's Stream Protection Rule. That would have basically protected clean water by forcing mining companies to stop dumping excess waste into streams. It also rolled back Bureau of Land Management regulations that had basically been prepared or amended to make sure that land use plans were properly proceeding pursuant to the Federal Land Policy and Management Act. It also rolled back Department of Interior regulations relating to takings of wildlife, and also closure procedures for the National Wildlife Refuge in Alaska. The Senate is now considering an amendment to the CRA called the REINS Act. That's the regulations from the executive in need of scrutiny, regulations from the executive being executive branch agency regulations. This would potentially address some of the separations of powers issues inherent in agencies, but it would also require Congress to become much more involved in really minute technical details rather than relying on agency expertise. So the REINS Act, it would not just permit Congress to continue issuing these joint resolutions to overturn regulations under the CRA. It would actually require congressional approval of any major agency regulations, defined as, among other things, those with a financial impact of over $100 million, before those regulations were to take effect. So this would definitely slow down the rulemaking process because Congress would have to be much more deeply involved. So there are some benefits that might be inherent in the REINS Act, but primarily it appears to me that it would really slow down rulemaking in a way that would not be beneficial to either the American public or regulated parties, which are companies. Okay, let's take a look at some distinct types of agency discretion. The most common forms of discretion exercised by agencies relate to their policies and their operations. So very broadly, this encompasses issuing regulations, creating and implementing policies, making enforcement decisions, accepting claims and applications, ordering protective actions, and what have you. Now, agencies have broad powers over how to organize their internal operations and carry out their statutory mandates. There's a lot of discretion there. So this discretion, it extends to most of the policy process. So that can include determining how best to set an agenda, including a regulatory agenda, how to define issues, especially specific technical issues, and how to formulate, implement, evaluate, and maintain policies. Some of these are purely internal policies, for example, how a human resources department within an agency runs. But others are policies that extend into the regulatory realm and impact the public and regulated parties. Now, while an agency's actions cannot exceed its statutory authority, that sandbox created by Congress, courts do tend to defer to agency policy and operational decisions. You saw this when you read portions of Gonzalez v. Reno in our textbook. That was the case where the little kid was escaping from Cuba with his mom. Their boat capsized. He wound up rescued by fishermen, taken to Florida, and his Cuban-American family wanted to file an asylum claim, but his father, who lived in Cuba, wanted the U.S. government to return his son to Cuba. And the 11th Circuit Court of Appeals, in that case, determined that it did not have any power to overturn this policy decision made by the Commissioner of Immigration and Naturalization Service to return the son to his father in Cuba. The court disagreed with the commissioner's decision, but found that the INS was acting within its authority when it determined that a 6-year-old could not submit an asylum claim except through his or her parent. Congress regularly authorizes and requires administrative agencies to implement and enforce regulatory programs. So as such, agencies have to routinely make decisions about when and how to promulgate regulations and then enforce those requirements against parties who violate the statute or the regulation. So prosecutorial and enforcement discretion, that includes investigations, prosecution, and settlement discretion, is a major example of agency discretion. Prosecutorial discretion within agencies is very similar to how our popular notion of prosecution works in criminal law. But instead of criminal enforcement, agencies provide administrative enforcement of laws and regulations. Now, the outcome can be similarly unpleasant if you happen to be on the receiving end, and individuals and corporations can be charged with both administrative violations, taken care of by the typical administrative agency, and also with crimes. Much like criminal prosecutors, agency prosecutors on the administrative side have freedom when it comes to setting their enforcement priorities, how they want to allocate resources towards those priorities, and how to make strategic enforcement decisions. Generally, deciding when or whether to enforce a statute or regulatory scheme. And this discretion stems from a combination of the president's constitutionally assigned obligation to take care that the laws be faithfully executed, and the APA's command that courts avoid reviewing discretionary agency decisions. So discretionary enforcement activities can include any range of actions. So it could be the imposition of penalties, the initiation of an agency investigation, administrative prosecution and adjudication, audits, or even criminal prosecution. So prosecutorial discretion is a very big issue in some cases, such as immigration and also state legalized marijuana. So, for instance, immigrants who are brought to the U.S. as children, properly known as dreamers, for a long time had relied on DOJ's discretion not to enforce immigration laws. Similarly, marijuana dispensaries in over 30 states have relied on the DOJ's discretion not to enforce federal drug laws in states where marijuana is legal. Now, the Department of Justice, which is also an executive branch agency, handles criminal and civil prosecutions. Other agencies handle administrative prosecutions. But regardless of the form of prosecution, agencies make these decisions to investigate violations based on the expense or inconvenience of an investigation, including the inconvenience of being brought into what we would call the court of public opinion. They also base it on the likelihood of discovering a violation. You know, agencies and criminal prosecutors, they're not going to waste time and resources if there's a 90% chance they're going to come up empty-handed. They also look to the expense or inconvenience of enforcing the law if they find a violation. And that's because there's no reason to investigate if the agency isn't actually going to take steps to remedy violations. Now, it is incredibly rare for an agency to be forced to launch an investigation. You know, unless Congress passes a statute that requires an investigation, it is up to the agency's discretion on whether or not it wants to launch one. So much like the decision to investigate, the decision to enforce a law also depends on the availability of resources and the seriousness of the offense. For example, with regard to availability of resources, the DOJ didn't want to get mired in lawsuits with a whole bunch of different states about medical marijuana, and so it made enforcing federal marijuana laws the lowest priority, particularly in states that had legalized marijuana. In terms of seriousness of the offense, for example, the Consumer Financial Protection Bureau took on mortgage companies that were giving the runaround to struggling homeowners seeking options to save their homes after the housing crisis. That was serious because individual Americans were losing their homes. And because of that, the CFPB decided that it was going to step in. It was important. And so it used its discretion to step in and start going after these mortgage companies. Agencies can delay enforcement. So it's not an enforce or not enforce. They can also opt to delay. So the underlying law takes legal effect, and conduct that violates that law remains unlawful, but the agency, in an exercise of its enforcement discretion, does not take action in response to violations until after a certain date. So for example, although there was a provision in the Affordable Care Act that required health plans to meet certain minimum coverage requirements in January of 2014, The Center for Medicaid Services actually announced that it wasn't going to enforce those requirements for at least a year. And the reason for the delay in enforcement is to give the public, both people and organizations, some time to come into compliance. It can take a lot of time and effort and money to comply with certain laws and regulations, and it would be unfair to start requiring compliance so very quickly after those laws went into effect. So agencies will go ahead and delay. In situations where an agency doesn't enforce, they refrain from bringing an enforcement action, courts have been historically cautious in reviewing the agency's determination. And this is because agencies are far better equipped than courts to evaluate all those variables that are involved in determining agency priorities and how to expend limited agency resources. So there was a case called Heckler v. Cheney that involved the FDA's decision not to prosecute. And the court found that the agency's decision not to pursue an enforcement action is presumptively unreviewable because those actions are committed to agency discretion by law. And that is a part of the Administrative Procedure Act. And there are three main reasons why an agency's decision not to take an enforcement action is just not well suited to judicial review. So first, agency decisions on whether or not to initiate enforcement, they are usually based on this complicated balancing of all these multiple factors. You want the efficient allocation of your limited resources, likelihood of success, relationship of the potential enforcement action to the overall strategy of the agency, etc. And courts are just not very well suited to perform that analysis because courts are not agencies. Second, the courts have noted that when an agency chooses not to act, the agency is not exercising any type of coercive power over other people. And if an agency is not coercing someone, then that is not as worthy as heightened judicial protection because the agency isn't making you do something. So you don't need the courts to step in to try to rein in the agency. And third, the court in the Heckler case found that an agency's discretion not to seek enforcement is very much analogous to an exercise of prosecutorial discretion that courts have traditionally been unwilling to review. If a prosecutor decides not to bring vandalism charges or burglary charges, it's really rare that a court would step in and tell the prosecutor that she had to do so. Now, the Heckler court did emphasize that this presumption of unreviewability can be rebuttable. So if an agency is not acting because it believes that it lacks the jurisdiction to do so, courts can step in and say, no, agency, you do have the jurisdiction. Or if an agency is expressly adopting a policy that is really extreme, it represents a total abdication of its statutory responsibilities, the courts could also step in. So for instance, if the Consumer Financial Protection Bureau decided that it was not going to regulate any type of financial services, a court could step in and say, hey, CFPB, your statute says you've got to do this. You are way outside of your ability to engage in discretion. Agencies also have discretion when it comes to making a decision to negotiate a settlement. So much like a U.S. attorney or a district attorney, agencies have really large caseloads, and negotiation and settlement avoids the time and expense of all these pre-trial procedures and then the trial itself. The Administrative Procedure Act does impose some limits on settlement discretion. Under the APA, agencies have to at least consider settlement offers. They don't have to take them, but they do have to consider them. And the APA tells agencies to settle when time, the nature of the proceeding, and the public interest really do favor settlement. So while agencies have to consider settlement proposals, they do have the discretion for the most part to accept them or reject them as long as they are considering the public interest, the effect of settlement on consumers, on regulated parties, and others. A lot of agencies have established rules that relate to settlement, and once an agency establishes rules, their discretion is further limited because they do have to play by those rules. Another form of agency discretion relates to claims and applications, and normally those are for some type of permit or funding, and that's why we've got like the VA. You can submit claims to the VA or to the Social Security Administration for various claims that accrue to you. And then the National Science Foundation, you can submit proposals for funding for research. So most agencies process some types of claims and applications. Example, Center for Medicare and Medicaid Services, that processes medical claims for payment or reimbursement. Like I said, the National Science Foundation processes applications for funding, and the EPA processes applications for and issues permits. And each agency can determine its method for processing these claims and applications as long as those methods don't violate the due process and equal protection clauses of the U.S. Constitution, which we will discuss later this semester. There are also protective actions. So that is another example of agency discretion. They can engage in protective actions. Some agencies exist to protect the health, safety, and financial well-being of the public. Those agencies have discretion to take protective actions, such as recalls. So for instance, the FDA might be recalling E. coli contaminated meat, or more recently, E. coli contaminated spinach and other leafy greens. The Consumer Product Safety Commission can seize goods that might be dangerous. So let's say there's a shipment of lead-based toys that comes in. They can seize those. Agencies can suspend professional licenses. So the State Bar Association can suspend an attorney's license to practice law. And agencies can also engage in actions to enforce civil penalties. Agencies that are permitted to engage in these protective actions have a lot of discretion when it comes to determining when, where, and how to do so. Agencies also have authority when it comes to tests and inspections. If you own a car, you have probably seen this up close and personal because you've had to schlep out to some emissions testing facility to have your car emissions tested, maybe annually or once every 2 or 3 years. The agencies that are authorized to establish testing and inspection requirements, those include agencies that might test for water contaminants, so the EPA, again, test for vehicle emissions, test applicants for professional licensing. I've got the California bar exam there in one of those photos. Now, we as individuals can challenge the validity or reliability of a testing procedure, but we cannot challenge agency decisions about whether to test and where to perform the test, because those decisions are left to an agency's discretion. Rulemaking discretion. This is where agencies create regulations. This is the most important form of discretion, and we are going to discuss it in depth in a few weeks. For today's purposes, what you need to know is that agencies have a certain amount of discretion when they fill these gaps left by Congress by promulgating regulations. And courts generally defer to an agency's interpretation of its statutory mandate and its interpretation of its own regulations, unless those interpretations are really unreasonable. And that brings us to the Chevron portion of the lecture. The Chevron doctrine and its related doctrines deal with judicial deference to agencies. So let's talk about that. What is deference? This is a concept that comes up a lot in administrative law. and it is literally a gauge of how willing a court is to defer to an agency's decision. So agencies make decisions on how to interpret the statutes that affect their missions, how to interpret the regulations they create, how to provide informal advice to those outside the agency. And these decisions are all based on the agency's opinion about its role in setting and enforcing policy. Deference is the amount of weight that a court gives to that agency's opinion. If you think about it, as individuals, we would likely defer to an oncologist about cancer treatment plans. The oncologist is a cancer expert. We would give his or her opinion a lot of weight because it is meaningful and we accept it as valid. Courts make the same sort of reckoning when it comes to agency opinions. If a court defers to an agency, the court will provide some oversight of agency action, but it is not going to substitute its own opinion for that of the agency. If the agency chooses to implement Plan A, the court's going to check, make sure the agency has the authority to implement Plan A, but the court is not instead going to require that the agency implement Plan B. If, on the other hand, a court does not defer to an agency, the court could disregard the agency's decision entirely, and in that case, a court could order the agency to implement Plan B instead of Plan A. Now, there are several types of deference. Agencies are in the executive branch, and the judicial branch can review executive branch action. We are again going to talk about judicial review in more depth later in the course, but for now it's just important to understand that courts do review agency actions, and they do so using 3 different standards of deference, and each standard gets its name from a court case. First up is Chevron deference, where courts give substantial deference to an agency's interpretation of its own statutory authority. This comes to us from the 1984 Supreme Court case of Chevron versus the Natural Resources Defense Council, and it is the most important case in administrative law. Chevron deference assumes that if Congress did not give the agency specific instructions to follow, courts should defer to the agency's interpretation of the statute it is administering, as long as the agency's interpretation of that statute is reasonable. Second is hour deference, spelled A-U-E-R, pronounced like an hour of time. It is from the 1997 Supreme Court case Auer v. Robbins. And in hour deference, courts give substantial deference to an agency's interpretation of its own regulations. So remember, Chevron is about an agency's interpretation of statute. Auer is about an agency's interpretation of regulations. So pursuant to Auer, courts defer to an agency's interpretation of its own regulations unless that is clearly erroneous. But this only applies when the language of the regulation is ambiguous and the agency's interpretation is not clearly wrong. And this form of deference has been limited by a case called Mead that we'll discuss in a moment. Third is Skidmore deference from the 1944 Supreme Court case Skidmore v. Swift. And in Skidmore deference, courts respect an agency's interpretation of its authority as long as that interpretation is persuasive. And for that reason, Skidmore deference is often referred to as the power to persuade. So if Chevron and Auer deference do not apply to a case, then Skidmore deference does. In 2012, a Supreme Court case involving the EPA called Decker versus Northwest Environmental Defense Center, it confirmed the idea that courts should defer to agency interpretations of their regulations unless it is clearly erroneous or inconsistent with the regulation. So Chevron was a landmark case. This is where the Supreme Court set forth the legal test for determining whether or not to grant deference to an agency's interpretation of a statute that it administers. And Chevron didn't really change anything. It just clarified the approach that courts were already using. The facts of Chevron dealt with amendments to the Clean Air Act that were designed to address the states that had failed to attain air quality standards established by the EPA. So through the Clean Air Act, states had to establish permit programs that regulated new or modified major stationary sources of air pollution. During the Carter administration in the late 70s, the EPA defined this source of air pollution as any device in a manufacturing plant that produced pollution. Then, during the Reagan administration, which followed the Carter administration, the EPA decided to adopt a new definition that allowed existing manufacturing plants to get permits for new equipment that did not meet those EPA standards, as long as the total emissions from the whole plant did not increase. The Natural Resource Defense Council challenged the EPA's decision to change definitions, challenged them in court, and won. Chevron Corporation was affected by this issue, and so it appealed the lower court decision. And as a result, the Supreme Court gave us the Chevron two-step test. So step one, does the statute show a clear intent of Congress? Sometimes this is phrased as, is there a statute on point? And if yes, the courts give no deference to the agency. The agency must follow congressional intent. But if the statute does not show the clear intent of Congress, then you move on to step two, which is the question of whether the agency's interpretation of the statute is reasonable. And if yes, the court gives deference to the agency and it allows the agency's interpretation to stand. But if the court finds that the agency's interpretation is not reasonable, then the court itself interprets the law and tells the agency what to do. So here is just the Chevron two-step test in flowchart form. You see the start. Is there a statute on point? If yes, courts don't defer to the agency. Agency has to follow the intent of Congress. But if no, then courts defer to the agency and they'll review agency actions in one of two ways. So courts ask whether or not Congress has explicitly delegated to the agency the authority to fill gaps. If yes, then the court reviews the agency action or regulation using either an arbitrary and capricious standard or a substantial evidence standard. And we're going to talk about those standards of review later in the semester. If Congress did not explicitly delegate that authority to the agency, then the court simply reviews the agency regulation or action to make sure that it is reasonable. The United States versus Meade Corporation case addressed the issue of when and where the Chevron doctrine should apply. So this case basically created Chevron step 0. And so in this particular case, the Meade Corporation, which makes day planners and calendars, it challenged a U.S. Customs ruling that had classified its day planners and calendars as diaries and notebooks that were subject to a tariff. So before Meade, it was clear that the Chevron doctrine applied to interpretations of things that had the force of law, so regulations and formal adjudications. But lower courts weren't sure whether it applied when the agencies did something that don't really carry the full force of law. And in this case, the U.S. Customs tariff rulings were made on a case-by-case basis. They didn't have any precedential value, so nobody was going to rely on any particular ruling going forward. And thousands of these rulings were made every year by 46 different regional offices. So the court found that these rulings were not worthy of Chevron deference and instead kicked it back to the Federal Circuit Court to determine if those customs rulings were entitled to Skidmore deference. So again, this just changed the start point to see whether an agency's action has the force of law. And if not, you ignore Chevron deference and you apply Skidmore. But if it does, then you move on to that whole Chevron flowchart. Before Meade, the Chevron doctrine applied to interpretations adopted in agency regulations, that's rulemaking, both formal and informal, and also to formal adjudications. However, the lower courts disagreed about whether Chevron also applied to interpretive rules, policy statements, informal adjudications, and the like. So after Meade, informal agency interpretations, including things like ruling letters, they are not treated like regulations. They do not receive Chevron deference because they are not preceded by notice and comment as required by the APA. They do not carry the force of law. They are not intended to clarify the rights and obligations of all individuals or all organizations. They apply only in one specific case. Now, there is always chatter about how the Supreme Court is on the verge of doing away with Chevron deference. And it's definitely true that Supreme Court Justice Neil Gorsuch is no fan of Chevron, and neither is Justice Clarence Thomas. But the demise of the Chevron doctrine has been overstated for many years, and we haven't seen it yet. So for me, I don't believe it until I actually see it. So there are a few points that I hope you will take away from this lecture. First is that vague and/or competing goals lead to discretion. Sometimes Congress can't or won't clarify its goals, and thus it implicitly grants an agency the discretion to resolve the policy dilemma by making its own choice. The agency gets to make its own choice. Second, discretion is inevitable, and it actually can contribute to a democratic public administration. Discretion can enhance public service competence by infusing agencies with the energy for change and a capacity for change. It can also promote political responsiveness. Public officials have to decide between competing interests and values, and we don't want those decisions to be replaced by a system of precise rules. Third, for better or worse, discretion does make individual moral responsibility possible within public administration. And fourth, the courts do tend to defer to agencies when those agencies are interpreting their statutory authority, their own regulations, and generally carrying out their constitutionally mandated operations. All right, that is the end of our lecture on discretion. Due this week, you've got a discussion on superhero immigration. You are going to need to figure out which U.S. laws might allow Black Widow, Superman, Thor, and Wolverine to become U.S. citizens. This is a collaborative discussion. Please work through the discussion boards and help each other narrow down the portions of the U.S. code that are going to be most useful for you. I also, in our classroom this week, have a link to the news items board. It's not because there is a due date right now for news items. I just want you to remember that you've got to post 5 of these throughout the semester, and only 1 per week counts for a grade. So do start posting those news items soon. As always, thank you for listening. I hope you have a great week. I will see you on the discussion boards.